It's what I call Groundhog Day. It repeats itself over and over and over. You work hard to finish the prior fiscal year, and then it starts anew September 1st. But it is good to see your faces here and your willingness to travel to Amarillo. We do appreciate that. It kind of helps us save a little bit of time, even though it kind of burdens your time. But again, thank you very much. We'll go on and call the docket. You've been informed about your time assigned to each side, so we will not go over that. Just the formality of an announcement. Let me know who's going to do the argument, because we'll let the court know, since there are two counsel at each table. We just want to make sure who's going to be doing the argument, even though you have already told me, but they deserve to know too. So with that said, the first case we have this morning is 07-25-00043-CR. Larry Gene Strickland II versus State of Texas for the appellants. Mr. Scherer.
Present, ready, Judge.
And you're going to be doing the only argument, correct?
Yes, sir.
And who's your guest?
This is Ethan Libby Pelletier. He is a public defender at the Amarillo E's office, and when I was originally appointed on this appeal, Ethan helped me write the brief, research some things on the brief, and he's going to sit with me today at counsel's table. The court is okay with that.
That works. Thank you very much. And for the appellees.
McLaughlin giving the arguments.
And you have a guest too.
This is the district attorney for Hood County, Mr. Ryan Sinclair.
Very good. Very good. And I understand this is your first time.
Yes, Your Honor.
Okay, watch out for these guys. We are prone to ask questions, so please do not take the questions as if we're being mean or anything. It's just we have questions and we want answers. It's like just talking to a fellow lawyer. Okay. That said, counsel, Mr. Scherer.
May it please the court, counsel. My name is Jeff Scherer and I represent Mr. Strickland. We are seeking relief of a concurrent sentence on two separate grounds. I believe this court is already familiar with the grounds we raised in issue 1, because they're very similar to the issues we discussed, or the facts and the law we discussed when this case first came before this court on the original appeal. So I'm not going to talk too much about issue 1 unless the court wants me to. I'll only discuss it briefly, because you don't really get to issue 2 unless you don't agree with issue 1. So
I do have one question on issue 1.
Yes, sir.
On the judicial notice portion of it. We have our own inherent judicial notice power. And so even if it wasn't proper for the trial court to judicially notice things from a different term without oral testimony, wouldn't we have the power to go and look at the record still and say, okay, now there is enough in the record to make sure it's stacked properly?
My understanding, and obviously the court can correct me if I'm incorrect, is that an appellate court does have a wider range of judicial notice powers. But this other alleged case, I think, would also have to be in front of this appellate court in order for this appellate court to notice records from another alleged case, is my understanding. And
and so here's what I'm trying to, I'm going to go a little further. So for example, like in a motion for summary judgment case, I know we're mixing criminal and civil, but hang with me for a second.
Yes, sir.
If there's summary judgment evidence that is excluded, okay, I don't look at it on appeal. Here's my question though. If the trial court took judicial notice and it was wrong, so maybe it should be excluded, can I not look at that or am I allowed to still look at it under our inherent judicial notice provisions?
I think that we're looking at the record, so I'm going to answer your question with a little bit of a narrative, if I may. If we're looking at the record, a court can really only focus on what's in the record before it. And judicial notice is supposed to be for things that are not in dispute. is my understanding as well. And we're disputing this because the record doesn't have anything like an exhibit or something else showing that this other case exists. We just have the judge
But does it not? If, for instance, the judge were just a lawyer who happened to be in the courtroom at the first trial, first hearing, whatever, and witnessed it all, could he testify as to what happened? If he had personal knowledge, he's there, he's seeing it. Could they call him and say, do you recognize blah, blah, did he identify himself as XYZ? What was he convicted of? Yes, I was there, I saw all this. Could he testify to that?
I feel like that would be somewhat improper since that other attorney would have represented.
No, if he was just a lawyer in the gallery.
Oh, I see. I think theoretically that is something that could happen.
So if the judge is on this side of the bench, they're personally witnessing everything because he's conducting the hearing, but he sees the same thing. He identifies the party, he knows the parties are, he knows who the case is. Why could he not then testify of his own personal knowledge? And isn't that kind of what he tried to do here?
Well, I think that goes into the judge is supposed to be a neutral arbiter, calling balls and strikes in the courtroom. And I don't mean to oversimplify the judge's job.
I understand.
But you know, if my understanding is the term of court rule is there for similar reasons that, you know, we don't allow hearsay. I'm not saying it's the same thing, but, you know, we try to have evidence that's reliable. Memories fade over time. And the term of court rule is there to draw a clear line, from what I understand, before someone can judicially notice their own records from a different term. It has to have some evidence in the record to support.
Why isn't the judge providing that some evidence from his own personal knowledge, his witnessing the events?
Well, there's also case law, though, that says it's the state's burden to prove up the priors, not the judges. You know, if I think we're getting into territory there where if we blur this line, you know, our judges aren't the neutral arbiter anymore. They're more of a engaged party. And I feel like that's a line we should be hesitant to cross.
So are you saying Bridges is the guiding case on this question?
I think it's the best rule case from the way I've read it. It says, hey, this is the rule. And I believe from what I remember about Bridges, it says it wasn't at issue here, but if it was from a different term of court, then this is the rule that, you know, would apply. If I remember my reading of Bridges.
Has to say it doesn't constitute evidence, or?
Well, I believe the judge in that case, it sat in the same district, if I'm remembering correctly. And it was like a week apart or something.
Right.
And he's like, hey, we just sentenced you in my other court. I'm going to sack you. And he was complaining on appeal that because it was in a different court of the same district, I think, that they needed to prove it up. You know, this like as if it was different court altogether, a different term, that kind of thing. And when they looked at it, they said, well, same judge within a week, same term of court. He can notice those records without them getting proved up, is what the facts were in Bridges, if I remember correctly.
Right. So Bridges doesn't represent the proposition that you should give no evidentiary weight to a finding that's in a different term, though, right?
I believe it does. I think it articulates that specifically, Judge. It just says that it didn't apply in that case. So he was complaining about it. The reason Bridges is a case that interprets the rule, but it didn't apply, is because it was in the same judicial district. So like a trial judge riding the circuit.
Right. And in the same term, though.
Correct. But they bring up the rule, like it mentions the rule statement about the terms of court.
Okay.
So the way I understand the rule that we're talking about is we can't take judicial notice of things that the courts file from different terms unless there is oral testimony linking things together. Why would the judges, he put stuff on the record. Why would him taking judicial notice and linking the man before me today as the man in these other cases? Why would that not count as oral testimony?
I've never heard of a judge being allowed to testify. And again, my understanding of judicial notice is always, it's supposed to be something that's not really in dispute. And so here, I think we have a clear dispute. It's not like we're asking, hey, is this courthouse in Amarillo?
Well, what is the dispute?
Well, the dispute is there's no actual hard evidence other than,
That goes back to what Justice Yarborough was asking. Why
Yes, sir.
isn't the judge comment that hard evidence? What's the fact dispute?
so I think
Your
the fact,
client wasn't that person, or your client was that person, or he was not convicted for that, or what?
so I can't comment on this other alleged case because I've never received any evidence about it. I'm not the attorney on this other alleged case. I wasn't there. So I think we're also dealing with a situation where the trial court is referring to records that I don't have in front of me. I don't know if the state had them in front of them. And there's an issue of fairness being allowed to at least examine those things. And so, at the remand hearing,
Was there an objection or based on grounds similar to what you just said? Judge, nobody disclosed this to me. I asked for, prior conviction information. It wasn't given. You can't testify because it wasn't given to me. That kind of notice, or?
the objection I made at the remand hearing, I don't think discussed that. I think this is a great segue, if I may, into the CCA remand opinion, if I could launch into that. I think that opinion conflicts with itself a little bit, and maybe that's because they're much more intelligent people than I am. It says on one hand, under the original adjudication hearing facts, so if we're talking about 4208A, which is the stacking statute for discretionary stacking from a trial court, the original hearing, no evidence was also presented, right? And the CCA said he had discretion to stack under those facts. The only way he has discretion to stack under those facts is if they are overruling the case law about this term of court discussion we're having. Because he noticed his own records without additional evidence in the original case, if that makes sense. And so if we are agreeing to that, which I'm not, but if this court believes that, that gets us to issue 2, which is my ex post facto argument, which is this new rule is an alteration of the legal rules of evidence under Calder, under the 4th prong. Because Calder has 4 prongs, increasing the or criminalizing behavior that was previously not criminal after it's occurred, increasing punishment for something after it's occurred, increasing the offense level of something after it's occurred. And the 4th prong is modifying the rules of evidence. And so we talk about a few different cases, one of them being Carmel v. Texas, where the legislature amended the outcry witness statute in all sex cases, and the guy was prosecuted in that case for child abuse, and he was convicted on many counts. And on appeal, he said this new law removing the outcry witness requirement, reducing the amount of evidence required to prove up this case, is an ex post facto violation. And he got some of his counts reversed in that case.
Which part are you saying is ex post facto here? The CCA's ruling, or ruling in this case, the present case?
So I believe in the CCA remand opinion that it's a 2-step question. If we are assuming that their opinion implicitly overrules this judicial notice case law, which we just had a big discussion about for the terms of court, saying we no longer need evidence in the record to allow a trial court to notice records in its own court from a different term, then that is the evidentiary rule change of judicial notice requirements in sentence stacking cases.
How would that be consistent if the CCA simply comes back and says, we don't agree that the rule in Bridges is the rule in Bridges?
Well, then I think they would be expressly overruling Bridges there.
Would that raise an ex post facto question at that point?
Well, if Mr. Strickland has a right to fair notice of the rules of the game, so to speak, you know, the rules of evidence or whatever they are at the time, and the court changes them on him, you know, to me, that kind of has a fair notice problem if it's an unexpected change. You know, and you know, many of the cases we cite talk about judicial modification of longstanding rules, like the Halifax rule in the Janika case. And you know, Halifax rule was apparently a rule that allowed or that required prosecutors who were putting forth evidence in a case to rebut exculpatory statements in such an exhibit, right? And in that case, Janika, he was convicted of murder. He did an interview with the news saying the mafia coerced him under duress or something like that to commit this crime. And he made it an issue on appeal that, hey, they did not rebut this exculpatory statement of mine, right? And I think the Texas court said that, well, it wasn't an ex post facto problem because they didn't really contest the statements. You know, they let the jury kind of handle that, evaluate if, you know, if that was like really a duress situation or something like that. And then I think the Fifth Circuit said, well, on a writ, that it's not an ex post facto violation that they didn't apply the Halifax rule because it was an outdated rule anyway, and it was heavily criticized, all those things. I'm not aware of anything that's heavily criticizing this well-established judicial notice requirement. And so to me, it seems to be a rule that's there. You know, why, without an express statement, you know, articulating why it wouldn't be an ex post facto thing to overrule it, I hesitate to think it would be,
Did the CCA,
or that it wouldn't be an ex post facto.
refresh my memory, did the CCA say in its opinion that this is retroactive, their decision's retroactive or not?
I don't recall that, Judge, but I will say this.
I mean, we can look it up again, no problem. Second question is, again, just clarify for me what you were denied fair notice of. What was the change? Again, just clarify that in my mind.
So, if I may, Judge.
Yeah.
And I think it goes back to the remanding opinion in this case.
Okay.
I'd like to read 3 portions of the opinion. They're very quick. On page 2 of their opinion, it says if accumulation order is not sufficiently specific, a remand may be permitted to allow the trial court to remedy the order. And then on page 10, and that makes it sound like the remand is discretionary. So this court could reform the consecutive sentence into a concurrent one if it wanted to. And I think it should for judicial economy. But on page 10, it says, we now apply part of Beatty's remedy principle and order a remand where the accumulation order is proper, which also implies this judicial notice requirement doesn't exist because they're saying the stacking order under these facts is proper, which is against all the case law at the time. But the evidentiary basis of the accumulation order is lacking. Then under the conclusion heading, it says the trial judge had authority to accumulate under 4208A, but entered an order that was not supported by evidence in the record.
So you need evidence. That's what CCA is saying, is you need evidence.
I would agree with that.
He didn't say how the evidence had to be presented, though.
They did not.
Well, then we don't have an issue with that's in conflict with the judicial notice language, do we?
I think we do.
Well, they needed evidence in prior law, didn't they, in your view? If there was a change, they needed evidence prior law, they need evidence now. How's that a change?
Well, I think evidence has to be there one way or another, but it's an interesting implication here.
In other words, they could have put on evidence the state could have put on evidence in a variety of ways. They could have gotten the conviction certified and put that on. They could have had presumably somebody testify from from prison saying, yes, this person was convicted and they were being held for a period of time. I don't understand the conflict that you're arguing under the ex post facto argument in light of what the CCA said.
So my reading of the CCA opinion is that they have overruled this judicial notice case law doctrine. And I believe I articulated to the trial court as much. Because my statement to the trial court was, my understanding, Judge, is that they're saying you have authority to stack, something along those lines. But that only happens under 4208A if they are saying you no longer need evidence in the record for you to notice records from another term of court. That's my reading. And that's why I argue both, though, in this, because I recognize the opinion is a little ambiguous. But
that brings us back kind of full circle to some of the questions we asked earlier with regard to why couldn't the judge testify on his own about what he witnessed in earlier convicting your client in a different case, what the conviction was for, the identity of your client.
I think it's a dangerous road to go down where in perpetuity, potentially, the trial court can just go back in time as far as the eye can see and notice records from 10, 20 years ago and say, I think you're so and so.
Is there a difference between judicial notice of a court's records, which a court generally can take notice of in term, if there's been a change in judges? So maybe that's why they're thinking maybe there's been a change in judges, so we're going to say term, as opposed to a situation where there's personal knowledge of the judge himself about what occurred. He's not testifying as to the records, he's testifying as to the fact of what occurred.
I don't remember the legislative history of the term of court statute. And it may not comment a whole lot about judicial notice. And I see I'm out of time.
You can want to finish your thought.
That I don't know if the legislative history of the term of court statute discusses judicial notice or not. It was such a nuanced topic to research. I only remember the cases, a few of them, under the sentence stacking context.
Thank you, counsel. You do have 5-minute rebuttal.
Yes, sir.
May it please the court. My name is Cecily McLaughlin, and I represent the Appellee, the state of Texas. This case was remanded by the Court of Criminal Appeals so that the trial judge could articulate enough information to support the accumulation order. And at that remand hearing, the trial judge obtained that information. This court should find that the accumulation order is sufficient and sufficiently supported and allow the accumulation of CR 14643 and CR 1249, because first, Judge Buffin articulated enough evidence linking the appellant to the 4 counts in CR 14643, and 2, the Court of Criminal Appeals did not establish a new rule for judicial notice, and therefore their ex post facto considerations are not, or moot, not necessary.
Stacking. Basically, CCA said, or the law is, to stack, you got to have this other conviction. And this other conviction has to be tied to this individual before I stack it, basically, correct?
Yes.
And that's the information needed, the specificity of that information, cause number, crime, identity.
Yes.
Why can't the judge, out of his own personal knowledge, provide that information? Opposing counsel's arguing maybe that he shouldn't be able to do that. But can a judge provide it out of his own personal knowledge?
Yes, in Bridges versus State, we do see that Specifically, the judge can articulate that he was the same judge and the same judge on the same case with the same person in the same court and even during the same term that was convicting somebody. And while through judicial notice can notice that and then use that information in the accumulation order.
Is
And
that based on personal knowledge though, or is that based on the contents of the file?
according to the reading of Bridges, it does appear that it's based off of personal knowledge. In Bridges, we see that it was only 7 days apart, and the judge both notices that he is the judge that was there and can articulate that he was the same judge that was convicting the individual in Bridges. And
We
here-
have rules of judicial disqualification and of recusal that prevent judges from taking the stand as a witness and testifying about facts in a case. And I guess one of my concerns is, it's one thing to say, I can look back and see what the file says, but if I'm testifying on my personal knowledge and just something that I was a witness to what I saw, that seems to go in a different direction. And I didn't know if you had any thoughts about that.
Judge testifying or not testifying, simply stating on the record that he was the person that was convicting someone and being able to identify that individual is not necessarily going to be something that's going to create an issue there simply because he's able to identify an individual. And we see that information for these kind of accumulation orders can come from practically any side. It can come from witnesses, the state, the defense themselves. We see in Miller v. State, any information that's provided by Miller can be used to prove out these accumulation orders. And looking
And
under,
that's the problem we have here. In all these other cases I've read, absolutely can come from witnesses, can come from the state, can come from other judgments being offered. In this case, the state offered no evidence, correct?
the state did judicially notice and used information in the file as evidence.
So did the state ask the judge to take judicial notice?
No, but the state does not have to ask the judge.
The
to take
judge
judicial
did this
notice.
all on his own.
Yes.
Okay, and so I'm gonna ask you the same question I asked Appellant. Unlike Bridges, we do have different terms issued here. The way I read all the occurring cases after Bridges is the rule is specifically, we can't consider judicial notice things from different term unless there is oral testimony linking the individual. Should we count the judge's judicial notice, him taking judicial notice himself, as oral testimony?
Yes, we should take the judge's oral statements that the individual was the same as they did in Bridges and use that to help prove up the information. But I would argue that the rule that we've been stating and the appellant has stated is not the rule that is existing in Bridges forward. We see in Bridges that they say that this rule does not apply. They do say that it's the same term of the court, same judge, same defendant, pretty much the same, 7 days apart. But at the very end, we see that they talk about how the court can judicially notice their own file and use it for accumulation orders. And then in Turner v. State, we see the judges walk through the entirety of accumulation law, and then once again talking about the fact that you can judicially notice, citing to Bridges and which is citing to Bullard, an 1899 case. But additionally, they also bring up the fact that cases have cited that judges should or judges may and should judicially notice when an individual is before them that has been in their court before and is known to them because they have been convicted. And we also see in Turner versus State that in 1986, Rule 201 was adopted, which allows the judges to judicially notice case files and provides a remedy when the documents that are being judicially noticed may not be trustworthy or safe, for lack of a better word to use, and known to the court. And in this
So
case,
does Rule 201 provide, did it supersede Bridges?
our belief is that Rule 201 is superseding Bridges and is that it's articulated in Turner. So Rule 201 is now the controlling rule for when judges should judicially notice on a case. And there is a remedy for someone who does not want a judicial notice, which is listed in 201. They may object as to the veracity or the trustworthiness of documents they're saying. And in this case, these are documents from the same court with the same judge. They're in the same courthouse. And if the appellant had objected at that time, they would have been able to view these files and these judgments from the judicially noticed case.
Has the Court of Criminal Appeals had any other discussion of Bridges since 1986? Does it still think Bridges is good law?
Turner versus State would be the last conversation that we really see the talk of the term of the court and the discussion about whether Bridges is good law when it comes to if you should judicially notice outside of the term of the court. And from there on, which we do see in Turner, they discuss that in both in Bridges and in Turner, because Turner initially took place in 1983, Rule 201 was not available to be used as a remedy for if you did not want something judicially noticed. And Turner contemplates whether someone can even judicially notice files outside of their own court. And it goes as far as to say, we will not decide that. But then once again states, judges are completely able to judicially notice a case that's coming from their court with convictions that have happened within their own court, within their own district, and are readily available to them and are being kept and well known.
Is there a difference between judicially noticing records of your court versus judicially noticing your own personal knowledge?
There would be a difference, but I would not say that the judge in this instance judicially noticed his own knowledge. He judicially noticed the court's case and then read into the record or announced the name, the court, the charge, the conviction date, the sentence, and then provided.
But he did a little bit more. Yes, he did all that stuff, but didn't he also say, I know this because I was there? In
Yes.
effect?
Which was adding to the veracity and his ability to judicially notice that he had been the judge that was there. He knew this person because he had been the judge presiding over the previous case, and that he was the one that signed the document and had pronounced these sentences for CR 14643.
So in effect, he was proving up the records.
Yes. And
Himself with his personal knowledge.
yes, which is the additional evidence that's needed, even if the new rule were not controlled by 201, but still by Bridges, that we would,
Without the state asking him to do that. He just did it on his own.
the state does not have to ask. The state asked the judge to accumulate. And when the judge announced that he was going to accumulate and then provided the additional information while proving up and judicially noticing the case, and proving the veracity and the truthfulness and how trustworthy these documents could be, he was judicially noticing and providing enough information for this accumulation order.
Just so we're clear, you said the state doesn't have to ask the judge to accumulate. You also believe the state doesn't have to ask the judge to take judicial notice of anything.
Yes, the judge does not, as stated in 201, the state does not have to ask the judge to judicially notice anything. Either side can and either side can reject. And in addition, if we look to the prong stated, the test in Jackson v. Virginia, they're stated by the appellant, which does say that sufficient evidence has been provided or insufficient evidence is not there. If there's no evidence under the record, or 2, the record conclusively shows reasonable doubt, we have enough evidence here to prove the accumulation order up, which includes the judicially noticed information provided by the judge, as well as his own information that he provided, that he personally recognized the individual, that this individual was the person that he had previously convicted, and that this was the person listed the name, the court, the charge, the conviction date, and the sentence. Therefore, getting over the burden in Jackson v. Virginia, because 1, there is evidence on the record, if only the evidence that he recognized the individual from this particular case, CR 14643, and the record conclusively showed that there was no reasonable doubt that this person was a different person. The appellant did not object that he was not the individual there. He just objected that to the manner in which the judicial notice was taken, and that it may violate de facto rules. Which leads me to our next. There is not a new judicial notice rule created by the Court of Criminal Appeals. In fact, this rule has been settled since Turner, that 201 is the presiding rule on how we should go about proving and when judicial notice is acceptable for accumulation orders. And even if that is not the new rule and the Court of Criminal Appeals was not ruling under 201 and judicial notice was improper because it was in the wrong term, there's still enough information here to prove up the accumulation order through the judge's own elicitations on the record that he recognized the individual with CR 14643, consistent with Ex parte Lewis, where a case number alone with prior occurring during the same term of court would provide enough evidence to prove up the accumulation order. And as such, there is no new rule, and there has been no ex post facto violations that would occur here.
I think in the Strickland remand opinion, the court literally says they have not reached this question before, whether the proper remedy is to delete or remand the accumulation order. Would that not constitute a new rule? For example, my understanding up until this remand from Strickland, if the appellate court got an order, a stacking order, and there was not enough evidence in the record to support the stacking, we would delete it. Okay. And now Strickland says, don't delete it, remand it back to the trial court. Would that not constitute a new rule, which could possibly violate the ex post facto?
No, because the remand merely allowed the trial court to provide on the record enough information, and it's merely a conclusion that was found in Beatty, but essentially that is put on the record as we did not say this in Beatty, but this is the rule that's following forward that we can't. We see that in Strahan, where the court even says that we have the ability to find the information where we need by, in the case of the appellate court, look back to the record. And in this,
Could the reviewing court always remand? Or
yes,
did they have to do what Judge Yarger was talking about before? They had to strike.
in the case of Strahan, the court could look to the previous record and simply fix the record with what information was there. And then in the most recent remand from the Court of Criminal Appeals, in this case, the court had the ability to remand to the trial court to elicit the information needed on the accumulation order when it was not clear by the record or not enough information had been provided, so that the accumulation order could be proved up, which was.
Yeah, I'm curious that's your input then on what the remedy would be. Let's say we agree with the appellant on this issue. Is the proper remedy to delete the accumulation order a second time? Or are we still in the same situation where we have an ambiguous state of the record, and per the previous CCA ruling in Strickland, we've got to remand it again and give the judge another try?
If we look to Strahan, this court could look to the record and decide if there was enough information to prove up the accumulation order and then go from there, or they could remand and potentially look at if the court could once again prove up that information. That would
You
be.
keep saying the court prove up that information. I mean, the state could easily just offer the judgments from the previous convictions.
Yes, which if we look to the purpose of 201
Could
or
be proved up in the trial court is probably the better terminology, as opposed to the court proving it up.
yes, Your Honor, that the trial court could prove this up in court or at a remand hearing. And if we look to Rule 201, that seems in line with the purpose of judicially noticing something, is that we could, and frankly, almost no different from judicially noticing something, to provide a certified copy of a document from the court that the court has in its record, and then have the judge have that into evidence, look at it, and then prove that up would be almost no different from judicially noticing this record that's already in the court's file.
Why not simply just offer the records of conviction? Why not have the state simply do that?
Judicial economy.
What, 4 sheets of paper on previous convictions, or what?
If the court did it here, we wouldn't be here. I mean,
That is fair.
Economy can cut both ways.
But the purpose of Rule 201, or allowing a court to judicially notice their own case file, is we talk about one case here, 4 pieces of paper, but if you have 50 cases, that amount of time does start to add up. And when these kind of documents are trustworthy or in the case file, and if there was an issue with their trustworthiness, you could object to their trustworthiness at that time, then for judicial economy's sake, the right thing to do is to judicially notice these files and get the records in that way through the trial court.
Yeah, but shouldn't the onus be on the state there? I mean, using your hypothetical, there's 50 cases prior. How's the trial court supposed to know that? I mean, shouldn't the state be putting on this evidence? Seems strange to me for the trial court judge himself to go have the burden to have to go find these 50 cases.
The state can, but the state doesn't have to. If the trial judge can at their own pleasure go ahead and order accumulation order and then proceed to notice their own case and proceed to prove that up, or if the state can, there truly is no difference.
And that's under Rule 201C, right? That the court may take judicial notice on its own, or it may do so if party requests it.
Yes, Your Honor.
So I guess what you're suggesting is that since the court can sua sponte staff, has the discretion to staff, doesn't have to give anybody notice of that. It should be the one to determine whether or not it has enough evidence to stop it and go out and find its own evidence in a way.
Not that the court should, but that the court can, and that the appellant in this instance could have objected to any of the information provided through the judicial notice, and that would have been the proper remedy.
I guess the unique scenario here is on the first go around, the state did not ask for a stacking sentence. Just the trial court did it on his own, right?
Yes, Your Honor.
My guess is if the state wanted to stack, they would have that evidence available.
The state can and could have asked to stack. The state did not have to in this direct instance because the court did sua sponte decide to stack.
Yeah, you would think that if state wanted it, they'd be prepared. Okay.
Certainly on remand.
Anything else, counsel?
No, Your Honor.
Thank you very much. Rebuttal?
Yes. Please, court.
How does Rule 201 not supplant the argument you're making here? I mean, in 1986, the rules of evidence now says that a court may judicially notice a fact that's not subject to reasonable dispute because it's generally known within the trial court's territorial jurisdiction. There's now a rule that doesn't give a limit on it being within its term of court or a particular time period. It's within the territorial jurisdiction.
Well, if there's a process for it to be disputed, it's not the same as, hey, where's this cross section? Is this in the county? Those are the types of questions where something's usually judicially noticed, or, hey, we did have a hearing in this same case.
Well, but these convictions aren't subject to reasonable dispute, are they? I mean, you didn't raise an objection that the records aren't valid or he actually wasn't convicted of these other offenses.
Well, I raised the objections that I thought were appropriate under the facts and instructions of the CCA at the time. I was quite shocked at the remand hearing when the state didn't try to move to admit alleged priors. I mean, it's not like it's difficult for them to prove up priors. They do it all the time with certified copies, fingerprints. And we had been in discussions about the case, because it had been on appeal, had gone up and down. And then we get to the remand hearing and they don't put them up. And so I was kind of like caught off guard a little bit. Here we are, because we wouldn't be here.
The way I read Strickland is, say we agree with you that it was improper to take judicial notice for their terms without oral testimony. The way I read Strickland is the proper remedy now is to remand it back to the trial court to get the correct evidence. Now, say this time the state just offers the prior convictions into evidence, so it doesn't violate any judicial notice rule. It doesn't, you know, there goes the ex post facto does. I mean, we're just back to how it was.
Well, I may have some objections made for another potential remand hearing, but I don't think, my understanding of the Strickland opinion is the remand remedy is a discretionary remedy. It does not say shall, it says may be remanded. And a lot of these cases are authored by Judge Onion. I can't remember any of them off the top of my head, but he talks a lot about appellate order. And he talks a lot about finality and resolving things when we can. If nothing else, then for judicial economy. And Banks v. State from 1986, criminal appeals, Court of Criminal Appeals case, which is 708 Southwest 2nd, 460. When an appellate court in Texas has all the necessary data and evidence before it for reformation, the judgment and sentence may be reformed on appeal. And so that is the remedy that we propose and advocate for here. I think it's time for this to be done. How many rematches does Goliath get against David? Mr. Strickland was prepared for court that day. This case went up to the highest court in the state. They remanded it down, and the state didn't do its job. And we're here again.
A lot depends on how many times Goliath gets up.
Yes, sir.
We may disagree with other courts on the number of times Goliath can get up, but that's not really up to us sometimes, is it?
It may not be judged, but I think here, or Justice, I think here it's completely within this court's discretion to reform this into a concurrent sentence at this level. And I think for judicial economy, if nothing else, that's very appropriate.
Anything else?
No, sir, I yield back my time.
Thank you very much. Your argument is submitted and you are free to go. We do appreciate your travel to Amarillo, excuse me. And hopefully you had some enjoyable time, ate at a good place, and welcome you back in the future anytime. Safe travels back, and both of you presented very well today. And congratulations on your first argument.
Thank you.
Thank you. We will take a very short recess.
All rise.